Okay, this is a very quick reminder of how we reached this point. There was an unexpected result in the 2016 referendum when the UK voted to leave the European Union. It created a period of major political upheaval, starting with the resignation of the Prime Minister immediately after the referendum result, a general election in 2017 when the government lost its parliamentary majority, and Article 50 of the EU Treaty was triggered, beginning the 2-year withdrawal process. Negotiations began with the European Union on the terms of withdrawal. Part of this was the government's early guarantee to protect intellectual property rights already registered under EU regulations, for example, EU trademarks. The mechanism chosen was to create comparable, often called cloned rights that were effective in the UK after withdrawal. In 2019, the UK government was unable to reach agreement with the European Union and gain approval of the UK Parliament. The withdrawal date had to be extended, and we had another resignation of a Prime Minister. Eventually, a general election is held, and the Conservatives under Boris Johnson are re-elected with a working majority and a mandate to withdraw from the European Union on 31st January 2020. The withdrawal agreement was approved by Parliament, and we entered the transition period ending on 31st December 2020. From 1st January 2021, the UK is outside the European Union, outside the single market, and outside the customs union. Next slide, Jason, and over to you.
Thank you, Tom. Now we're going to look at just some general trends in recent years. So as you can see, there's been a significant growth in the volume of UK and EU trademark applications filed between 2016 and 2020. There were 65,710 UK trademark applications filed in 2016, compared to the 137,000 UK trademark applications filed in 2020. That represents an increase of over 71,000 applications and a growth of 208% over that 4-year period. If we look at EU trademarks, there were 135,470 EU trademark applications filed in 2016, and that's compared to the 177,092 EU trademark applications filed in 2020. This increase is not as steep as the increase in the volume of UK trademark applications filed, but it still represents a growth of 130%. This trend appears to be continuing. If we look at the first quarter of 2021, so January through to March, there were over 52,000 UK trademark applications filed, compared to the 27,864 UK trademark applications filed in the first quarter of 2020. So this is a 186% increase on the previous year. If this trend continues, the forecast for the total number of UK trademark applications filed in 2021 is over 200,000. This would represent a 316% increase on the volume filed in 2016. Back to EU trademarks again. So in the first quarter of 2021, there were 49,115 EU trademark applications filed. If the rate of filing continues on the same trajectory, we forecast that there will be over 196,000 applications filed in 2021, and that would represent a 145% growth from 2016. Interestingly, it looks like the total volume of UK trademark applications filed in 2021 could actually exceed the volume of EU trademark applications filed. And then if we look at the growth trajectories, they've been very similar since 2016. This could potentially be attributable to applicants filing simultaneous UK and EU trademark applications to mitigate the risks associated with the uncertainty surrounding the Brexit withdrawal process and the prospect of a no-deal scenario. As we will see later on, there has been an increase in applications filed by Chinese applicants in the UK and EU. But in the UK, one of the key drivers for the growth is the increase in the volume of UK applications filed by UK applicants. Back over to you, Tom.
Thank you, Jason. So this graph shows the month-by-month trend of UK applications filed since the beginning of 2017. What we already know and can see clearly from this graph is that there was already a steady underlying growth in UK trademark filings. The UK system for the last 20 years has primarily been used by companies operating only or primarily in the UK and for brands intended primarily for the UK market. The EU system was used by larger companies with products and brands in multiple EU countries. From the 1st of January, the UK system has to be used for both, and trademark applications that might have been filed in the EU only now need to be filed in the UK and the EU. The trend started in 2020 as trademark owners sought to secure their position in the UK early. And as Jason just said, a number of applicants filing already duplicate applications in the UK and the EU. From the second quarter of 2020 onwards, there's a noticeable increase as businesses realised that Brexit would definitely happen. From October 2020, there was already no possibility that pending EU trademarks would register before 31st December and thus qualify for a cloned right. And so at that time, it was already necessary to make an application in the UK. So we see another increase in the fourth quarter of 2020 until the end of the year. And since 1st of January, the increase has been greater still. In quarter one of 2021, UK trademark filings even overtook EU trademark filings in March. Next slide, Jason, and over to you.
So I'm going to look at filing trends in the UK in a little bit more detail. So I should just point out first that the database used to generate this data has also included cloned rights, as it's not possible to filter those out. So as I said, UK-based applicants are by far the biggest filers of UK trademark applications. In the first 4 months of 2021, UK applicants filed over 39,000 UK trademark applications. This is an increase of 14,824, so 61% over the compared to the first 4 months of 2020. The increase in UK trademark applications filed by UK applicants in 2021 may be a sign that UK businesses and individuals are gaining more confidence in the UK economy. This may be due to the successful vaccine rollout, the Bank of England's GDP growth forecast of 7.25%, and the increase in certainty regarding the future relationship with the EU. The volume of UK trademark applications filed by Japanese applicants has been consistent over the past 10 years, with a slight downturn since 2019. As you can see here, there has been a significant increase in the volume of UK trademark applications filed by Chinese applicants. This is unsurprising, as there has been a significant increase in applications filed by Chinese applicants at major registries around the world. For example, in October 2020, Chinese applicants surpassed US businesses to become the largest source of US trademark applications filed at the USPTO. This prompted the USPTO to publish a report into the impact that the filings may have on the US trademark register. The USPTO claimed that the applications originating from China lack value and clutter the register. In the UK, there are UK firms that specialise in filing applications on behalf of Chinese applicants. In 2020, 7 of the top 30 representatives, calculated by volume of UK trademark applications filed, were companies that specialise in filing applications on behalf of Chinese applicants. The biggest filer of UK trademark applications in 2020, in terms of professional representatives, was a company that specialises in filing UK trademark applications on behalf of Chinese applicants, and they filed over 800. So if we look at the EU, so the volume of EU trademark applications filed by Chinese applicants has increased by over 1,000% between 2010 and 2019. That's an average growth rate of 33.2%. Interestingly, Chinese applicants overtook German applicants in 2020 as the biggest filers of EU trademark applications. This trend has continued into the first quarter of 2021, as Chinese applicants have filed 9,160 applications versus the 7,217 applications filed by German applicants. If this forecast is correct, the gap could become even larger by the end of 2021. There is no use requirement in the EU, and specifications can be drafted very broadly. So there is a genuine risk that the EU trademark register could become cluttered. The EU IPO published a report in 2020 that looks at the evolution of EU trademark applications and registered community designs filed by Chinese applicants. The EU IPO report concludes that the office will closely monitor the evolution of filing volumes from China to properly adjust strategies and capabilities. And finally, if we look at Japanese applicants, again, fairly consistent over the past few years, Japanese applicants typically file around 5% of the total number of EU trademark applications filed. And that's over to you.
Thank you. Thank you, Jason. The prevailing rate of opposition in the UK is about 4%. That is to say, 4% of UK trademark applications are formally opposed. Oppositions come at the end of the application process, and so there is a time lag in terms of being able to look at numbers. The UK IPO forecasts that the rate of opposition will continue to be 4%. This seems to be the case in 2020 and in the first quarter of 2021, where the number of oppositions is growing, and you can see that on this graph. It is interesting to see that the number of oppositions in the EU seems to be falling. This could be connected with Brexit and less interest in opposition proceedings by UK companies. It could be that opponents are choosing to fight in the UK first, where opposition procedures are different, and in particular, where the applicant is obliged to respond to the opposition. The UK IPO notifies owners of prior UK rights when their trademark registration is cited in their search report. Notifications often lead to opposition, both threatened and formal proceedings. The UK IPO reports a significant increase in volume of notifications, an average of 3.7 notification letters per application since 1st January, compared with 2.6 notifications per application before then. Next slide, please, Jason. So on this slide, we see that the number of oppositions involving Chinese and Japanese companies, you can see that in both cases, the number of oppositions is growing with a time lag, creating some provisional data on the right-hand side of the bar chart. And we can expect that growth to continue in the UK as the number of applications increases. Please note that in both cases, they are predominantly defending opposition proceedings rather than being the opposing party. And on the right-hand side, we highlight some of the most common parties involved in opposition proceedings. And the green chart, part of the chart, shows where oppositions are defended, and blue is where the opposing party is the offender. Next slide, please, Jason. So just looking at the position in the EU, the picture is rather different. For Japanese companies, shown at the bottom, there is not much overall growth in the volume of oppositions. And the balance between opponent and applicant, so between the green and the blue, is much more even. At the top, for Chinese companies, you see that there is big growth. That reflects an increase in filings from China. And still the balance is predominantly as applicant, so defendant in opposition proceedings. So you can see that Chinese applicants defend, but Chinese owners seem not to oppose applications either in the UK or in Europe. Okay, next slide, please, Jason, and over to you.
Finally, I'm just going to wrap up with some conclusions and quick tips. So as we have seen, there has been a significant increase in UK trademark applications. There's been a creation of over 1.5 million cloned UK rights on the 1st of January, 2021. It's important to note still that owners of EU trademarks that were pending at the end of the transition period can still file comparable rights by the 30th of September 2021. Clearance searches are, as a result, now more complicated and even more important. UK trademark searches should include EU trademarks until at least the 30th of September 2021 to ensure that cloned rights are included. There's potentially an increase in opposition risks as well because of the increase in UK notifications. It's important to consider appropriate strategies when dealing with oppositions and notifications. Some of the clone rights may be vulnerable to revocation. And we've got a question on this, which I will answer in a minute. It's important to note as well, when filing dual applications, that the systems do differ. There's different opposition procedures in the UK and EU, and there's different grounds that can be relied on, and thus there's a different choice of forum and tactics that can be employed. With the emerging ownership of trademarks by Chinese companies, clients may wish to adopt specific strategies and tactics for dealing with Chinese counterparties. A distinction should potentially be drawn between legitimate Chinese applicants and imitation brands, as this will have a bearing on the overall strategy and tactics. And that brings us to the end of our segment of the slides of the talk, and I'll now pass it over to my colleague, Andrew Hawley.
Thank you, Jason, and good afternoon, everybody. Now we've just seen the details on the filing strategies and the trends that are being implemented post-Brexit. So what we're going to look at now is the more practical implications of the trends in trade deals that have happened since the UK left the EU. Next slide, please, Jason. So in this area, I'm going to look at 3 key points, and these are the considerations that brand owners really need to look at since the UK has left the EU in January this year. Firstly, how has the post-Brexit landscape affected the UK, and how is the UK progressing now it is no longer part of the EU? So primarily, how has the landscape changed in the UK? Is it business as normal, or are there new opportunities that brand owners outside the UK and inside the UK need to look at to maybe take advantage of the opportunity presented by Brexit, which is now a reality? Obviously, this has to be caveated somewhat with the COVID pandemic, which is currently ongoing, which I doubt was foreseen by the powers that be when Brexit was an issue. But we can hopefully see some indication of what trends may be happening in this area. Secondly, I will also be looking at some of the trade deals that the UK has agreed since it left the EU. Primarily the well-publicised trade deal that was agreed with Japan back in October of 2020, and considerations that brand holders may need to look at in order to take advantage of this trade deal. And finally, what practical steps, particularly should Japanese brand owners consider in order to take full advantage of the free trade deal between the UK and Japan and the new post-Brexit landscape in the UK. Next slide, please, Jason. So firstly, how has the post-Brexit landscape affected the UK, and how is the UK progressing now it is no longer part of the EU trading bloc? Just as a reminder, touched on by my colleagues Tom and Jason, the UK did, after much pontification and length of time, it did finally leave the EU on the 1st of January 2021, and the working trade deal between the UK and the EU came into force that same day. A free trade deal, in essence, aims to encourage trade, usually goods, but occasionally in services, by making it cheaper and more cost effective for countries to trade with each other. This is often achieved by reducing or completely eliminating trading tariffs, reducing taxes or charges by governments for trading goods across borders. This is a particular hot topic in the UK at the moment, because you may have seen on the news earlier this year that there were some initial teething problems for UK brand owners to be able to move their goods into the EU post the Brexit transition period ending. Particularly, you may have seen in relation to seafood and fish, which is very popular, UK seafood and fish, which is very popular in the EU, particularly for certain products, and where it was friction-free and could be traded under the old EU agreement when the UK was part of it, that's no longer the case. So certain brand owners in the UK were having trouble moving these goods to the EU, which were obviously fresh seafood, which needed to move quickly in order to be sold on the EU market. So that was one example of a negative of the post-Brexit era. Trade agreements, also aim to remove quotas, which are effectively limits on the amount of goods which can be traded. Under the old agreement with the EU, when the UK was part of the EU, there were obviously no quotas in force. Free movement of goods and services allowed goods and services to be flowed both ways. But since the end of the transition period, quotas were a possibility, and these are things that the UK now needs to consider when making trade deals with other countries. The trade deal that was agreed prevented any tariffs and quotas being introduced, which would have made it more expensive to trade with the EU. This is particularly important because the EU is the UK's largest and closest trading partner. Geographically, we are still very close to the EU. Brexit has not resulted in the UK being pushed further away from Europe, but it has made it slightly more difficult for UK brand owners to move their goods into the EU, and potentially there was a possible issue with EU goods being shifted into the UK. For example, the German car manufacturers were particularly concerned because German cars are quite popular in the UK, and the UK is quite a large market for big brand holders such as Mercedes, BMW and Audi. But at the moment, the post-Brexit era seems to be working okay, but it does remain to be seen whether that can be continued in this new post-Brexit landscape. Before Brexit, the UK was automatically part of any trade deal that the EU had negotiated with another country. So part of the trading bloc, it automatically extended those deals to the UK. For example, the EU had around 40 trade deals covering more than 70 countries at the time the UK left the EU. So these were originally and automatically affected once the UK left the EU. The UK, however, has made deals to continue trading in the same way with 63 of these countries. So the impact and outcome is not quite as bad as some media outlets were predicting, but ultimately the UK is in a slightly worse position on the trade deal front from being outside of the EU rather than being inside the EU. Next slide, please, Jason. So one of the positives that the people who are in favour of Brexit like to say is that now that the UK is outside of the EU, it has full ability to make its own trade deals with other non-EU countries rather than being part of the EU trading bloc and automatically included in any trade deal negotiated and agreed by the EU as a whole. For example of this, the UK signed a trade deal with Japan on the 22nd of October 2020. This was the first deal that the UK had managed to reach with a non-EU country that was outside of the existing EU deal. This was seen as significant and highly praised in the UK press because the total value of UK-Japan trade, imports and exports was around 31.6 billion in 2019, or around 2% of the UK's total trade. So a rather significant amount of trade that the UK was very pleased to arrange a deal with Japan on this basis. On the 31st of January 2021, the UK government announced that it would apply to join a free trade area with 11 Asia and Pacific nations called the Comprehensive and Progressive Agreement for Trans-Pacific Partnership, or shortened to CPTPP. Current members of this include the major economies in Asia and the Pacific nations, such as Australia, Canada, Japan, and New Zealand. So quite a significant trading bloc there that the UK is hoping the membership of will increase the possibility of further trade deals. Separate to that, the UK government is also holding trade talks with the US, Australia, and New Zealand. To date, there has been no real significant progress on this, but the UK government is hopeful that trade deals can be agreed with these countries in time particularly as the UK shares a lot of cultural, language and economic similarities with these countries, and also historic relationships that may aid both parties in a separate trade deal. However, the initial impact of Brexit on the UK economy is difficult to assess. As we've seen from Tom and Jason's presentation, UK filings are certainly growing across all numbers, but it's very difficult to see how that is actually affecting the economy on the ground. There are factors for this. Obviously, the pandemic is a big factor, which is affecting economic outlook and trade across the whole world, although the UK Bank of England has quite an optimistic outlook for growth in the UK in the near future. So in the next few months up to the end of the year, it may be easier to see if that trend is true and that the UK is actually, the UK economy is blossoming after the Brexit finalisation. However, up to by January 2021 was the first full month of trade after the exit from the EU, and the UK media, the news media at the start of March highlighted that there had been a significant drop of around 40% in the value of UK exports to the EU as border checks slowed down trade between the two blocks. Now, this was, I mentioned this earlier, a lot of perishable goods such as fruit, vegetables, seafood, livestock such as meat was being held up at the border, and EU businesses such as restaurant groups, wholesalers of food were disappointed that the goods were not arriving fresh like they used to before the UK exited the EU. So they were looking elsewhere outside of the UK for their produce to be imported into the EU, either other EU countries or other countries where they had a more workable agreement. So that was one prime example of where the extra layer of border protection and extra layer of red tape was slowing down the UK's ability to export its goods to the EU, which would not have been a problem under the Brexit. Would not have been a problem before Brexit was finalised. Next slide, please, Jason. So how will these, the free trade deals that the UK has agreed with Japan, how will this influence and affect brand owners in the UK and also in Japan? So what opportunities are there to take advantage of this new economic landscape and the agreement between the two countries? As I mentioned, the UK and Japan entered into this free trade deal in October last year. It was a very significant deal. It was the first deal that the UK government had agreed post-Brexit, and it was seen as a very much a flagship deal for the UK government to prove to the UK people that trade with other countries would not be significantly affected just because we were no longer part of the EU. This was significant because 48% of the people in the UK did not vote to leave the EU. So there's a lot of political pressure to win over the people who were not in favour of Brexit, but maybe would like to see the best outcome for the UK now that Brexit is a reality. The trade deal between, trade between the UK and Japan continues to grow, with the trade deal projected to inject an additional 15 billion into the respective economies, on top of the current value of 31.6 billion that I mentioned earlier, which is the current value of the relationships. Just on that, Japanese goods and services are popular in the UK, and the UK-Japan trade deal is certainly aimed at benefiting certain sectors that are popular. Digital and data are popular in the UK from Japanese brand owners, financial services, Japanese food and drink, and also the creative industries in particular. Sort of effectively, Japanese culture Japanese food, Japanese entertainment is becoming more and more popular in the UK as people become more aware of that. And the UK is, especially London, is a very cosmopolitan city, and there are certainly opportunities there for Japanese brand owners to maybe take advantage of this deal and to maybe grow their business in the UK. However, if Japanese brand owners are looking to take advantage of the new Brexit landscape and to look at the UK market as a major market, they do need to give consideration to certain trademark and further IP protection of their key brands, as if that growth does happen, they need to protect their key assets. As mentioned by Tom and Jason earlier, the UK is no longer part of the EU trademark and design system. So any Japanese brand holder which is looking to grow their business in the UK will certainly need to look at separate UK trademark and design registrations in order to protect their key strategic IP assets. As we saw from the figures earlier, the Japanese applicants are fairly consistent in filing both their UK and EU trademarks, but one of the implications of the UK and Japan trade deal may be that we see a slight rise in the number of UK trademark applications by Japanese applicants as they fully realise that the growth that they may take advantage of in the UK due to the trade deal and the popularity of Japanese culture and food and other goods and services will require them to protect their IP assets by way of UK trademark or design registrations. It is also important to realise that the UK is no longer part of the EU Customs Union, so there will be separate procedures in place to protect against possible counterfeit goods entering the UK. And I know that's something that my colleague Charlie Baum will be speaking about shortly. Next slide, please, Jason. So key considerations, what practical steps Japanese brand owners should certainly consider in order to take advantage of this new trade deal. Such deals have clear impact on UK export businesses and by extension on their respective IP strategies. And obviously that flows the same way from Japan into the UK. So we would say that businesses who are looking to export into the UK, maybe in greater numbers, and to grow their market share in the UK, need to have a clear strategic plan on how to implement that, and also a plan to protect their key IP assets, such as trademarks and designs, which will be on sale in the UK. And as they gain more traction in the UK market, protection becomes more and more important. The potential opening up of the UK market certainly does mean that a strategic approach is required for filing both UK and EU marks. As mentioned, we do need to consider filing separate UK trademark and design registrations, and that should be factored into any business decision taken by a Japanese business looking to extend their reach throughout the EU and the UK. And following on from this, we would always advise businesses to conduct a timely trademark clearance search in order to assess the risk of the ability to use and register a brand in the UK. This is particularly, well, more relevant at the moment due to the uptick in the amount of Chinese applicants who are filing on the UK register, and also the point that all the existing EU trademark registrations have been cloned onto the UK register, and also owners of EU trademark applications which were pending by before or on or before the 31st of December 2020 can still file trademark applications in the UK up to the 30th of September 2021. So in practice, at the moment, when we conduct a trademark search, We are concentrating on the UK register in order to advise clients on the risk in the UK, but we are also looking and checking the EU register to make sure that we cover any pending applications that may still be applied for in the UK and that can claim the EU priority filing date. So the advice from that that element of the slide is, if you are looking to grow your business in the UK and you are looking to proceed with the USAN registration, searching and full clearance searching is an absolute must in order to allow you to fully assess the risk of proceeding on that basis. Away from trademarks slightly, UK design registrations are also needed to be considered for any innovative goods which may be capable of obtaining this extra IP registered right. Ultimately, UK designs are quite cheap and it's quite easy to obtain a UK design registration, and the breadth of coverage can be a nice addition to protecting the branding of the trademark registration. And it allows Japanese businesses to be comfortable knowing that they have all their IP assets fully protected in the UK as they look to grow their brands here as a result of the trade deal. And as a pan-European firm with offices in the UK and EU, we at Marks Clerk we feel uniquely placed to advise Japanese brand owners on their strategic IP requirements in both the UK and the EU, particularly in this uncertain era now as the post-Brexit landscape starts to take shape, and particularly as the UK is starting to come out of the very restrictive lockdowns on businesses and people due to the COVID pandemic. There is a sense of optimism in the UK at the moment that better times are coming, and businesses will certainly be looking to take advantage of that. And we would be happy to give any strategic advice for Japanese businesses who are looking to take advantage of this hopefully fruitful new era in the UK and in relation to UK and Japanese business relations. Next slide, please. So that's the end of my talk. I hope that was informative and interesting, and I'll pass over to my colleague Charlie Balm, who will now present further information on the Customs Union controls after Brexit. Over to you, Charlie.
Thank you, Andrew. Good afternoon. I'm going to talk to you about customs controls in Europe, so a slight change of focus from previous speakers, and how brand owners can make use of these measures to stop infringing goods at the UK and EU borders post-Brexit. So next slide, please, Jason. With that in mind, I plan to talk to you about why brand owners should be interested in the enforcement of intellectual property rights by European customs authorities, how the customs IP application for action, or AFA, regime operated before Brexit, and then finally, what has changed since Brexit. So next slide, please. So why should brand owners be interested in IPR customs enforcement in Europe? Well, as you can see from this slide, the single biggest reason, in my view, is because the customs regime is highly effective at stopping infringing goods. These figures, which are from 2019, show that customs officials seized fake goods at the EU's external borders, which included the UK at that time, worth nearly 760 million euros, representing some 41 million items. And those numbers increase year on year. For example, in 2018, by comparison, customs seized some 27 million items, valued at over 738 million euros. And remember that these are the figures for goods detained by customs. Significantly more counterfeit goods go undetected and make it across the border and into the internal market. The OECD, the Organization for Economic Cooperation and Development, estimated in 2016 that almost 7% or 121 billion euros worth of EU imports from third countries were counterfeit. Figures for the UK was similarly staggeringly high, estimated to be roughly £13.6 billion, or 3% of UK imports. Next slide, please. So a brief word on the source and type of goods that are typically being detained by EU customs. Where do the goods originate? Well, you can see from this EU data that PRC, or China, as it has for many years, remains the leading source of counterfeit goods in terms of both number and value of goods. And in terms of the goods themselves, while there is obviously a wide range of counterfeit products out there, cigarettes and other small but high value items like ICT devices continue to top the list of seized goods. As you would expect, and although it's not shown on this slide, of all the seizures, trademarks predominate as the single most infringed IP right. And this is important because it means that customs authorities are highly experienced at identifying these types of suspect shipment, meaning that customs enforcement is particularly useful for brand owners operating in these markets. Next slide, please. So finally, on this point, customs authorities in Europe are very proactive and actively encourage rights holders to file AFAs, or applications for action. This is a press release issued last December in connection with counterfeit COVID-19 related products. As you can see, they've seen a dramatic increase in detentions as infringers seek to exploit the uncertainty caused by the pandemic crisis to import and sell fake medical and protective equipment. And in response to this problem, EU Customs made a specific request to rights holders dealing in COVID-19 related products to urgently file customs applications to help customs take action against the entities trading in these products. The reason for this is that customs positively want to intercept infringing goods, but they need help from rights holders to identify the infringing products from the genuine products. And the information provided in support of rights holder applications, which I'll come and talk to a bit later, is an important part of the process and helps customs controls, make customs controls so effective. So to conclude on why brand owners should be interested in IPR customs enforcement, infringing and counterfeit goods are clearly damaging to business revenue and brand reputation. And it's therefore important that brand owners use all means at their disposal to combat this trade, including use of customs enforcement at Europe's borders as part of their wider brand protection strategy. And as we've just seen, those customs measures are effective. And as I'll explain shortly, they are also relatively low cost and a useful way to obtain intelligence on the trade in infringing goods in the EU and UK. And finally, just before I move on, it is important to note that while the customs measures are designed primarily to target counterfeit goods and brand space, identical marks, identical goods, the regulations obviously extend to infringing goods generally. It's a very useful tool. Next slide, please. So how did the customs AFA regime operate before Brexit? The current EU IP customs regime is governed by EU Regulation 608 of 2013, although the enforcement system itself was established by an earlier regulation in 2003. So the system has been in operation, in fact, for over 15 years now, and is subject to regular review to see where it can be improved. The application process is relatively cheap and straightforward and operates via two mechanisms. Firstly, by prior application, and secondly, following a so-called ex officio action. I'll explain both mechanisms briefly. So firstly, applications. These may be filed nationally or on an EU-wide basis, depending on whether you seek to rely on national or community EU rights. If going down the community AFA route, the application is filed via a local customs authority, but if granted, it'll be recorded with authorities across the EU, or at least in all the member states you designate. There is no filing fee, but the rights holder must provide an undertaking to pay for certain costs associated with the detention of suspect shipments. For example, storage costs and liability should customs wrongly detain goods on the rights holder's instruction. The rights holder must also provide supporting information, which I mentioned earlier, to help customs identify not only infringing goods, but also genuine goods. This is clearly important so that customs only intercept infringing shipments and do not mistakenly interrupt legitimate business. The supporting information must also include a list of local contacts who can liaise with customs in the event of any detention. In my experience, the attitude and efficiency of customs authorities can vary quite significantly across the EU, but having local contacts in place makes it easier for customs to connect, for example, it removes language barriers, and so local contacts can play an important role in developing effective working relationships with local customs. There are also simplified procedures available, which the rights holder can opt into. For example, customs will, if requested, destroy small consignments of suspect goods, infringing goods, without notifying the rights holder. This won't be appropriate for all brand owners, but it can be useful for high-value counterfeit goods that are often shipped in small packages. Tobacco products are a prime example. I also mentioned the need for an EORI number, a European operator's registration and identification number. This is a relatively new requirement introduced last September for all rights holders wishing to lodge or file an EU AFA, whether or not they actually trade in Europe. This is really just an extra administrative burden. It is fairly straightforward to apply for this number, and it shouldn't be seen as a barrier to obtaining an AFA. Once accepted, applications last 1 year, but can be renewed. And the application and supporting information can now be managed and updated online via a new IP enforcement portal. And just finally on this point, just worth noting that certain goods or shipments are not covered by the regime, and in particular, grey market goods are excluded, so parallel imports, product overruns, things like that. Turning to the second mechanism, while most customs actions are initiated by prior application, as I just explained, customs authorities do have the power to act on their own initiative, so-called ex officio action, although this is rare, with less than 1.5% of detentions initiated via this process. The reason it is rare is because customs are required to notify the rights holder within 1 day of detaining the shipment, and they often struggle to identify the rights holder in time. And this procedure also only allows the rights holder a very short time to file an application, 4 days, if it wants to investigate the status of the goods. Given these limitations, I advise clients not to rely on the ex officio process, but it is a useful safety net. Next slide, please. So briefly, what happens when customs find suspicious goods once an AFA has been filed? First, the authorities send details of the shipment to the rights holders' representatives. These details usually include sample products or photographs and basic information on the consignment, for example, the number of articles. However, the rights holder can ask for more details to help them assess the status of the goods, for example, contact details for those responsible for the shipment, for example, the importer or consignee. As I mentioned earlier, this is a useful way of getting intelligence on the trade in counterfeit goods for any particular brand owner. The rights holder then has an extendable period of 10 working days to confirm the status of the goods, whether genuine or infringing. And at the same time, customs authorities contact the alleged infringer and ask if they consent to the destruction of the goods or otherwise object to the detention. Depending on the response, the goods will either be released, destroyed by consent, or held pending the outcome of civil proceedings for infringement. So next slide, please. So the important bit, what has changed since Brexit? Well, not much, thankfully. The main change is that you must now file at least 2 AFAs, 2 applications for action, one for the EU following the procedure I've just talked about, and one for the UK. Helpfully, the new UK regime is modelled on the EU regime, but with, I like to think, slightly less red tape. It's based on similar law, the Customs Enforcement of IP Rights Amendment EU Exit Regulations 2019, simply amended the existing regulation that applied to the UK to make it applicable to the UK only, as opposed to Europe-wide. The main differences with the EU regime are that you do not need to have an EORI number, it's the number I mentioned earlier, or equivalent number for UK AFAs. And also, I may have seen how significant this will be, HMRC, so UK Customs will no longer share seizure information with other EU customs authorities. I've just flagged there on the slide, certain rights holders can still file an EU AFA for Northern Ireland, although it is still the UK, given its special status at the moment within the new EU-UK trading relationship. But this right is only in respect of certain protected geographical indications. So finally, just put a question there whether Brexit will lead to an increase in the trade in counterfeit and infringing goods between the EU and the UK. As with the pandemic, I expect counterfeiters will, if they haven't already done so, seek to exploit some of the uncertainty, confusion, and opportunity caused by the new post-Brexit trading arrangements. And I expect this will increase the trade in infringing goods. And there have been some press reports on this. Brand owners should therefore check that their brand enforcement strategy remains effective to counter this threat. And one simple, cost-effective, and potentially high-impact step they can take is to file applications for action in the UK and in the EU if they have not already done so. So that's the end of my talk. Thank you very much for your time.
はい、スピーカーの皆様、どうもありがとうございました。それではこれからQ&A の方に移らさせていただきたいと思います。質問が、何点か来ております。まず一番最初に、こちらの方に受け付けております質問の方、日本語の方で、ご紹介したいと思いますので、それを、スピーカーの皆様は、英語で翻訳されたものをお聞きになった上で回答をお答えいただければと思います。よろしくお願いします。まず一つ目の質問ですが、出願から5年以上経過する EU トレードマークを英国で全く使用していなかった場合、つまり EU トレードマークとしてはすでに不使用取り消しが可能な期間になっている場合、ブレグジットによって当該 EU トレードマークに基づき付与される英国商標は直ちに不使用取り消しの対象になるのか、ブレグジットから5年以内に使用を開始すれば、当該英国商標は取り消しが免れるのか、また、出願から5年以上経過する EU トレードマークが英国のみで使用されていた場合、英国の使用から5年以内にブレグジット後の EU 域内で使用を開始すれば、不使用取り消しが免れるのか。以上でございます。よろしくお願いします。
Thank you for the question. So, yeah, the quick answer is if the comparable right is vulnerable to revocation, then yes, it will be vulnerable. So it's important to note that if there's a UK trademark comparable right, the prior use in the EU will be taken into consideration to be able to show genuine commercial use. So the test is to defend a revocation action, the proprietor needs to show that it's made genuine attempts to either create or maintain a market share. So if they only have use in the EU, although they will be able to rely on that use for the initial period, as time progresses, it's going to be a lot more difficult for them to argue that they've made genuine attempts to maintain a market share in the UK. Oh, apologies. So I'll just start again. So with when you're trying to show genuine commercial use in the UK, you've got to show that you've made genuine attempts to either create or maintain a market share. So if you only have use in the EU, that use will be taken into consideration for showing genuine commercial use of the UK trademark. But as time progresses, if there's only use in the EU, it will be a lot more difficult to argue that you've made genuine attempts to maintain a market share for that registration.
はい、ありがとうございました。他にご質問のある方、よろしくお願いします。ただいま、Q&A の方に書き込みを英語でしていただいている方がいらっしゃいます。スピーカーの方、どなたか、この英語で書かれているものを一旦読み上げていただいて、その上でご回答をお願いいたします。
Yeah, okay. The question is it necessary to appoint a UK attorney for cloned compatible UK registrations? Please let us know if it is detrimental not to do so. Okay. The short answer is it is not absolutely necessary at the moment, but it is certainly advisable to appoint a UK representative because of it's the flow of documents from the UK IPO. At the moment, if you have an EU representative, then they will be cloned onto the UK register. They will receive all documents such as any revocation actions, renewal reminders, or any other correspondence from the UK IPO. If you have a cloned international, an EU designation, sorry, from an international registration, the representative will either be the WIPO representative or the applicant themselves. So they will receive all documents from the UK IPO, which we believe is a risk, and it is far easier to appoint a UK representative to ensure that the UK IPO correspondence is handled by an attorney who is familiar with the UK law and practice. I would just mention that Marks Clerk have taken on many UK representations for many clients around the world, and I will mention that we do this, the initial takeover of representation for any UK cloned compatible right, free of charge. So in summary, it is not necessary, but we certainly, it's strongly advisable to appoint a UK representative for any cloned compatible UK rights.
May I add one or two comments, please? So I think for the moment, it is not necessary to have a representative in the UK for registered comparable trademark rights. It is permissible to have a representative within the European Economic Area, but not beyond the UK, not beyond the European Economic Area. This means that some cloned rights have been created from EU designations within international registrations, and they may not have a representative listed within the European Economic Area, and those cloned rights will need to be need to have a UK representative appointed. The requirements will change after 3 years from 1st of January 2021, and after that time it will be necessary to have a UK representative on all UK trademark registrations, whether they're cloned or legacy registrations. So for the moment, it's not a requirement, but after 3 years, it will be required to have a UK representative. And any new matters, new applications, new oppositions, they do require a UK representative now.
ありがとうございました。他にご質問のある方いらっしゃらないでしょうか。Q&A、日本語で記入していただいても結構ですので、質問のある方はよろしくお願いします。 ご質問ありませんか？もし入力に時間がかかるようでしたら、質問がありますと最初に入れていただければ、こちらの方で待つこともできますので、いかがでしょう？はい、追加の質問がございました。こちらは日本語ですので、こちらの方で読み上げさせていただきます。もともと UK の登録を持っている状況で、クローン UK 登録ができた場合、双方を維持しておいた方がいいのでしょうかというご質問です。
Shall I answer? If the two sets of registered rights are identical, then there is no need to retain the cloned right or retain both. If they are not identical, for example, if one of the rights has an earlier date of registration, then you need to think carefully about which is the better right to retain. And it may be in some situations appropriate to retain both rights. For example, where you have an older right with an earlier registration date and a narrower set of list of goods and services, and the later filed registration has a broader list of goods and services, then retaining both will give you wider protection. It is also possible to merge trademark registrations. It is also possible to convert UK national trademark registrations into designations within the Madrid Protocol. So it's a little bit complicated, but in principle, if the two rights are the same, there is no advantage in having both.
はい、どうもありがとうございました。続きまして、一件 Q&A の方に英語で質問が入っていますので、読み上げていただいた上でご回答をよろしくお願いします。
Yeah, shall I take this one? So,
Okay.
The question is, what are the major and important differences in trademark opposition procedures in the UK and EU? So there are various differences. For example, in the UK, you can file a TM7A, a notice of threatened opposition, which will extend the opposition period by a further month, and it can potentially lead to a more favourable cost award in the event that the opposition is successful. There are also additional grounds that can potentially be relied on in the UK compared to the EU. One of the most notable grounds that could be relied on in UK opposition proceedings is it is possible to oppose on bad faith, whereas in the EU it is not possible to rely on bad faith in opposition proceedings. You have to wait until the mark proceeds to registration to file an invalidity action on bad faith. Also in the UK, there's different requirements when submitting evidence. So, for example, when you submit evidence in the UK, you've got to do so by way of witness statement, whereas in the EU, there is no such requirement. Also in the EU, there's a different procedure insofar as in the UK, If the applicant does not file a defence, the application will just be refused at that point before the opposition proceedings officially start. However, in the EU, if the applicant doesn't file anything, the opposition proceedings will go all the way through to a decision. And finally, another difference in the UK, where cost awards are issued, it's a lot easier to be able to recover those cost awards. And in the event that the applicant doesn't pay the cost awards, there will be a notice to say that they haven't, which can potentially be detrimental. Whereas in the EU, it can be more difficult to enforce cost awards, and sometimes the cost of doing so is greater than the potential cost award that can be recovered.
はい、ありがとうございました。あと2件質問が入っております。1件目、日本語ですので、こちらの方で読み上げたいと思います。本日はありがとうございます。中国人の EU、UK 出願が増えているようですが、異議申し立ての際に気をつけるべきことは何でしょうか。というご質問です。よろしくお願いします。
Shall I take that one? What we observe from our own personal experience is that Chinese applicants are reluctant to engage when there is an opposition or a threatened opposition. It is important to bear that in mind. Most applicants from other jurisdictions are prepared to negotiate or amend applications in order to avoid formal or extended opposition proceedings. Our experience is that Chinese applicants are less willing to engage in that way. And one of the options that we see for our clients is where a Chinese applicant has now an EU trademark application and the corresponding UK application, then it is important to make sure that an opposition is filed in the UK, because the applicant is then obliged to file a reply, a counter statement, otherwise their application is lost. So the UK system forces some kind of engagement from the applicant during opposition proceedings. So it's important to utilize the UK system where that is a possibility. Otherwise, what we see in the European Union system is that Chinese applicants do not respond and wait for a decision to be issued, which causes delay and runs a risk of unfavorable circumstances.
はい、ありがとうございました。続いての質問ですが、英語でQ&A の方に入っておりますので、この英語の方、ご質問を読み上げた上でご回答をお願いできないでしょうか。よろしくお願いします。
Yeah. Should I take this one? Yeah. So the question is, does the UK IPO send reminders for renewal to the holder of a cloned registration? And the simple answer is they will only do so if there is no representative listed against the UK cloned registration. But as Tom mentioned earlier, this is a requirement for some designations from international registrations. So in practice, the UK IPO will look to send the renewal reminder to a form of listed representative on a cloned registration. So at the moment, if you had a cloned EU registration and it had the original EU representative, they would receive the renewal reminder. However, if you change that to a UK representative, they will receive the renewal reminder.
はい、ありがとうございました。続いてのご質問ですが、日本語になりますので、こちらの方で読み上げさせていただきます。マドプロ EU 指定の UK クローンを所有していますが、UK を指定して事後指定した場合、代替制度、リプレイスメントは適用されるでしょうかというご質問です。よろしくお願いします。
So, okay, I think I understand the question. Yeah, so my understanding of this question is if this proprietor has a UK trademark registration cloned from an EU designation of an international, because the UK registration that's been cloned will be a national UK trademark registration. If they then file a subsequent designation in UK, will that subsequent designation then replace the earlier EU cloned right? My understanding of this is the answer to that is yes, if the particulars are identical. There's also a process, it will happen automatically as well, but there is also a process in the UK to record the replacement. Yes.
はい、ありがとうございました。続いての最後の質問になりますけれども、Q&A の方に英語で。
I can take this one, Meg, if that's okay. Would you like me to read it out?
英語で書かれていますので、ご質問を読み上げた上でご回答をよろしくお願いします。
Okay. If somehow there is a failure to make a cloned registration, is there any remedies to fix it? The very short answer is yes, there is. We have had some examples where the UK IPO have been mistakenly not cloned over EU registrations, or they have cloned them over incorrectly. We have highlighted these to the UK IPO and they have remedied them very quickly. It's not a formal process, it's just highlighting to the UK IPO that they have made an error and then they will fix it.
はい、ありがとうございました。現在、Q&A に入っております質問は以上で全てになりますが、皆さん他にご質問あるでしょうか？もしよろしければ、ちょうど時間になりましたので、これで本日のセミナーを終了させていただきたいと思います。はい。それでは、スピーカーの皆様、本日はどうもありがとうございました。また、ご参加者の皆様、今日お忙しいところ、ご出席いただきましてありがとうございました。これで、AIPPI ジャパン報酬商標セミナーを終わりたいと思います。